International criminal law is one branch of international justice. It has expanded greatly since the end of the Cold War. Other branches of international justice deal with A. The resolution of disputes between states, mostly in charge of the International Court of Justice, and B. Petitions of individuals against states for alleged violations of their human rights, which are decided by regional systems, including regional courts, established in Europe, the Americas, and Africa. Criminal law is the branch of law which deals with offenses so egregious that society has decided to apply the organized force of the state to suppress them. It is therefore a last ratio, meaning a measure of last resort. Criminal law possesses a substantial dimension which has to do with the value that has been violated by the offense. Criminal law also has a procedural dimension. It refers to the due process of law through which criminal liability is established or dismissed. There is also a third dimension in criminal law which relates to the execution of the penalty, commonly known as penitentiary law. Since the 17th century, piracy has been considered a universal crime, that is, an offense punishable by any state wherever the pirate may be found and however distant the place of the crime might have been. The importance of freedom of navigation and commerce in an increasingly capitalist world demanded such a harsh legal approach when dealing with pirates. In the aftermath of the First World War, an attempt was made by the victors to prosecute Kaiser William II for crimes committed against international morality and the sanctity of treaties, but to no avail since the Kaiser was granted political asylum in the Netherlands. National courts are competent to try crimes committed in their territory. They are also competent to try other crimes if their domestic law gives them that power. In recent decades, several international treaties have granted the states, which are party to them, extended basis for national criminal jurisdiction. For example, states may seek to prosecute certain crimes even if they were not committed in their territory, provided that the alleged perpetrator is a national of that state, according to the principle of active personality, or that the victim is so, according to the principle of passive personality. National courts are also competent to try crimes other than those based on such principles in conformity with the universal jurisdiction principle. Universal jurisdiction, originally reserved for piracy, can be invoked nowadays by national courts to prosecute war crimes committed anywhere by anyone, national or foreigner. In the early 2000s, some hybrid criminal courts were created, meaning that these courts have a national as well as an international component. For instance, the special courts for East Timor in 2000, in Cambodia in 2001, and in Sierra Leone in 2002. There are two kinds of international criminal jurisdiction: ad hoc tribunals, created to try crimes committed in certain countries in times of war or civil strife, and permanent international criminal courts. It was only after the Second World War when the first ad hoc international criminal courts were established, the Nuremberg and Tokyo tribunals on 1945 and 1946 respectively. These courts would prosecute the major German and Japanese criminals responsible for war crimes, crimes against humanity, and crimes against peace. Just as free trade was humankind's most important common interest in the 17th century, the respect for human dignity and human rights became a cornerstone concern for the international community after the atrocities committed during the Second World War. During the Cold War, the momentum towards international criminal justice came to a halt. After the end of the Cold War, two main ad hoc courts were created by the UN Security Council to address the humanitarian catastrophes occurred in the former Yugoslavia in 1993 and in Rwanda in 1994. In 1998, the states parties to the Rome Statute created the International Criminal Court, the first permanent jurisdictional body in charge of prosecuting crimes under international law. There are currently, at the beginning of 2014, 122 states parties to the Rome Statute and the Court, yet they do not include the United States, China, and Russia. The Court comprises the Presidency, a judicial division including a pretrial, trial, and appeals chambers, the Office of the Prosecutor, and the Registry. As mentioned, the International Criminal Court is the first permanent international criminal tribunal. According to its charter, called the Rome Statute, the court is competent to try 4 basic international crimes: genocide, crimes against humanity, war crimes, and the crime of aggression. These crimes are not subject to any statute of limitations. That is, they can be prosecuted no matter how long ago they were committed. Arguably, amnesties or pardons are not possible for these crimes either. A case may be filed before the International Criminal Court by 3 main actors: a state, party or not to the Rome Statute, the prosecutor of the court, and the UN Security Council. The ability of the prosecutor to initiate proprio motu an investigation is supervised by the court's pretrial division. The crimes must have been committed by natural persons after July 1, 2002, within the territory of a state member, or by a national of that state member, or in the territory of a state that has accepted the jurisdiction of the court, or by a national of such state, or in any other state of the world, provided that the UN Security Council refers the situation to the court. The jurisdiction of the court is only activated if the state competent to try the offense is unable or unwilling to conduct a serious and effective due process of law. This is known as the principle of complementarity. This principle is key to understand the importance and nature of the court in the international community of states, because it defers initially to state sovereignty, and only after such sovereignty has proven to be misused by the state, the court intervenes, thus securing the independence of states as well as encouraging better criminal prosecution within them. The court is currently prosecuting cases in 8 states, including Uganda, the Democratic Republic of Congo, the Central African Republic, Mali, Sudan, Libya, Ivory Coast, and Kenya. Although all of these states are African, the court is also monitoring situations in Afghanistan, Georgia, Colombia, Honduras, and South Korea. In 2012, the court issued its first 2 rulings, one condemning Thomas Lubanga to 14 years of imprisonment for war crimes in the Democratic Republic of the Congo, and the other one acquitting Matthew Gujolo for alleged war crimes and crimes against humanity in the Democratic Republic of the Congo. Some may think that these 2 rulings reflect a poor cost-benefit ratio after 10 years of functioning of the court, but others appraise the existence of the court from a principled perspective. According to the Rome Statute, the crime of genocide consists in acts committed with the intent to destroy, in whole or in part, a national, ethnical, racial, or religious group as such. These acts include the killing of members of a group, seriously harming them, inflicting conditions to bring about its physical destruction, preventing birth within it, or forcibly transferring children from it to another group. These crimes are crimes committed as part of a widespread or systematic attack against any civilian population with knowledge of such attack, including murder, extermination, imprisonment, enslavement, torture, rape, persecution, enforced disappearances, and the crime of apartheid. These crimes are great breaches of the Geneva Conventions of 1949 and customary international humanitarian law committed during international as well as during non-international armed conflicts. Finally, the crime of aggression, recently defined in 2010, means the planning, preparation, initiation, or execution by a person able to direct the military or political action of a state of an act of aggression that constitutes a manifest violation of the UN Charter. Please visit mookchile.com and watch our next class.